Welcome to Advisory Opinions. I'm Sarah Isgur. That's David French. David, very excited about today's episode.
I'm excited about it too. This is going to be different in lots of fun ways. Well, same and different in lots of fun ways.
So I want to start with this New York Times story about the makeup of the lower courts and the effects that Trump and Biden have both had on them. Then I want to take us back to 1983. I'm not even going to tell you why. We're just listeners, just trust us. It was an interesting year. And then we've got some great little circuit decisions.
Yeah.
A January 6th related decision out of the DC circuit.
Yeah.
So, David, we'll start with the New York Times. Just to level set here, there are 677 district judge positions and 179 circuit judges. As the New York Times, they have nice little graphics for this. So of those 179 circuit judges, basically exactly 50% were appointed by Republican presidents and 50% were appointed by Democratic presidents. 43 were Biden, 53 were Trump. At the district court level, 39% appointed by Republican presidents at this point, 55% appointed by Democratic presidents at this point, 44 are vacant, 44 seats are vacant. And then, of course, the Supreme Court, 67% by Republican presidents, 33% by Democratic presidents. But of course, that's not how each circuit is, right? They're not 50-50 by circuit at all. So I'll just run through the circuits. First circuit, 100% Democratic appointees. Federal circuit.
That surprised me. First circuit, you said that so fast. Please slow down. First circuit, 100% Democratic appointees.
In fairness, it's not that big.
No, it's not that big, but that's pretty amazing.
And the first circuit, by the way, we're going to go sort of northeast to, I don't know. I'll try to explain what states we're talking about. But here, it's Maine, Massachusetts, and New Hampshire is the first circuit. The federal circuit is 67% Democratic appointees. They do, patent law-y stuff, trademark-y stuff. All right, DC circuit, 64% Democratic appointees. You know what the DC circuit is. Fourth circuit, that's Virginia, West Virginia, North Carolina, South Carolina, 60% Democratic appointees. 10th circuit, Oklahoma, Colorado, New Mexico, Kansas. What is that over there? Utah. 10th circuit's 58% Democratic appointees. 9th circuit, the giant one, Alaska, Arizona, California, Nevada, Washington, Idaho, Oregon, Montana. The 9th circuit, only 55% Democratic appointees at this point, David.
Yeah.
Second circuit's New York, Vermont. Is that a Rhode Island in there? Probably. Connecticut. Second circuit is 54% Democratic appointees. 7th circuit, we're now going to cross the Rubicon. We're now entering into majority Republican appointees. The 7th circuit is Illinois, Indiana, and Wisconsin. That's 45% Democratic appointees. The 6th circuit, Michigan, Ohio, Kentucky, Tennessee. You're in the 6th circuit, David.
Yes.
44% Democratic appointees. 3rd circuit, Pennsylvania, New Jersey. Is that Delaware? Yeah, Delaware. 3rd circuit, 43% Democratic appointees, but they have some vacancies. So actually it's only 50% Republican appointees also. 11th circuit, we talk about the 11th plenty, Georgia, Florida, Alabama, 42% Democratic appointees. 5th circuit, Texas, Louisiana, Mississippi, that's my home, 29% Democratic appointees, so 71% Republican. But the most Republican circuit of all, the 8th circuit, which is like the whole country. All right, it's Arkansas, Missouri, Iowa, Minnesota, North Dakota, South Dakota, and Nebraska. 91% Republican appointees, 9% Democratic appointees. And yet we never talk about the 8th Circuit, David, because there's such a quiet, happy Minnesota nice circuit, I think. Just a lot of congenial people up there.
Yeah, it's really interesting to me because if you had told me beforehand what's the most Democratic circuit, what's the most Republican circuit or the most liberal and most conservative, I would have said fifth most conservative, and second circuit most Democratic or most liberal. I was not tracking the first, and I was not tracking the eighth, and which is interesting because they're if the first is 100% Democratic and the eighth is or liberal, and the eighth is 91% conservative. And it's interesting that you don't have more big cases coming out of those. Now, of course, that has some geography elements, but in such a forum shopping world that we live in, it is
David, this goes to the point that just because you're appointed by a Republican president or by a Democratic president doesn't tell you everything. So that's why people aren't picking those, is because the Eighth Circuit isn't wackadoo conservative, actually.
Right.
The New York Times piece also had this interesting little nugget, and this is actually why I wanted to talk about it, because it looks on its face like it undermines my theory about the end of the filibuster ushering in this new era of more extreme judicial decision-making and the appointment of judges that fall on the further extremes of their ideological sides, because you don't need bipartisan support anymore. So here's the line. Mr. Biden's judges, on average, were somewhat more liberal than those nominated by his Democratic predecessors. Mr. Trump's judges were, on average, ideologically similar to those nominated by previous Republican presidents. And you sort of look at this graphic that they have, and they all look about the same. And then you look at how they judge that. This was weird. The database calculates a score for judges' ideologies using records of campaign contributions they made before they were confirmed to the bench and became barred from making such contributions. The scores do not account for the judges' actual rulings. Those are harder to track ideologically, because very few cases in the lower courts have a direct impact on political questions. Even so, the creators of the database say the scores have proven to be reliable indicators of judges' ideological leanings after taking the bench. But, like, is it how much money they gave or who they gave the money to?
Yeah.
That was weird.
I thought that was interesting as well. And the other thing is, I do get what they're saying, though, about it's hard to judge a lot of their cases on an ideological spectrum, because let's just take a case that we talked about at some length before. This was the Third Circuit TikTok case that had 2 Trump appointees and 1 Obama appointee agree that TikTok may be held liable for pushing the blackout challenge algorithmically pushing the blackout challenge into the feed of a young girl. Who crossed the line there? Who crossed over in that case? What's the ideological valence of that case? And it's extremely unclear to me. And the interesting thing, Sarah, as our ideological categories just get more and more and more scrambled, and I really think the average American does not know, they're not beginning to grasp how much the ideological categories are getting scrambled right now. But as these ideological categories get scrambled into a judiciary that was nominated by and large under old school ideological categories, it's going to get even more difficult to make that assessment. So I do find the campaign donation thing interesting, but here's what I also find interesting. So they said that Biden's judges on average were somewhat more liberal than those nominated by his Democratic predecessors. And the little chart that they have bears that out. It's almost as if you took the judges nominated by Biden and judges nominated by other Democrats, took the exact same sort of blob and moved it half a tick to the left, just like half a tick, right? But then if you look at the Republican chart, it doesn't seem to bear out the paragraph below it, because the paragraph below it says Trump's judges on average ideologically similar to those nominated by previous Republican presidents. But if you look at the chart, it's a lot fatter on the right edge of it on the Trump nominees than it is with other Republicans, which tends to have a more even distribution for longer. And so the chart seems to say, yeah, the nominees were in the same range overall, but there were more on the right edge. So if all I did was look at the chart, Sarah, and not look at the paragraph underneath it, I would have thought, there's your filibuster theory coming into view, because it wouldn't happen immediately, because
Right.
99% of the judges who are up for nomination over the last several years have come up through the old system, and they're sort of legacy scholars and legacy practitioners under the old system. This is what I would expect, a move towards those extremes, not in a big jump, but in a kind of a step by step. So the chart looks like your theory, the paragraph doesn't.
Let me also add that as you say, the donations are going to become less predictive, to the extent they are predictive at all, as the scramble happens. I also agree that this was never going to happen overnight. It was going to happen slowly, because you have to, if you've changed the incentives for people who want to become judges, it takes them a hot second, because your
sure.
current pool is still of the old incentive group. But the third thing is that and again, I'll only speak to the right where I know more about it. The places that people are looking for judges post filibuster is different. And they tend to now be looking at people who have worked for maybe state solicitors general, or these ideologically based litigation groups. So think Alliance Defending Freedom, Beckett Fund, Pacific Legal Foundation. Yeah, you pick it. Well, if you work at any of those places, you're not working at a big law firm. You don't have a ton of money for political donations. So I'm just not sure the political donations are going to be there to the same extent, because that's not how, of course, anyone who's looking to pick a judge, they're not going to be looking at political donations at all. I mean, except to the extent that it's like a deal breaker if you donated to AOC or something, I guess, on the right. But they're looking at a career dedicated to the principles, if you will. And that's going to generally not come with as much money to do said political donations. So I think the whole premise is getting scrambled post filibuster also.
Yeah, no, I do think that is an interesting, and I do think, you have seen judges coming out of the ACLU from Democratic presidents. There was not the same big right-wing legal infrastructure until really recently. I remember when I was graduating from law school, Sarah, in 1994, there were, as near as I could tell, in the entire country, 3 conservative, legal, free speech, religious liberty positions available. 3, like at nationally working public interest law firms. And now, you've got ADF, you have ACLJ, you have Beckett, you have Institute for Justice, you have Pacific Legal, and many of these might have been much smaller 30-something years ago. I mean, some of them didn't even exist at all. But there's a much bigger universe. And also there's a bigger universe, in my experience, of lawyers working for legislators. There's a much bigger universe of state solicitors general. That's a thing that has really mushroomed. And sort of the work that solicitors general do has mushroomed. And so it really is the case that there's just a much bigger public interest, conservative, right-leaning public interest infrastructure that exists now than existed when I came out of law school. The big bulk of your pro bono religious liberty work and free speech work was done by lawyers who were doing it as a hobby, who were doing it on the side. And now you've got a ton of specialized law firms. It's a very big sea change. I remember even 20 years ago, young law students would say to me, I remember talking at Christian Legal Society at Vanderbilt Law School. This had to be about 15, 18 years ago. And I asked them how many wanted to go into public interest law. And every hand went up. Every hand went up in the whole Vanderbilt CLS. And all of those hands were probably 3 times the total number of jobs available across the country. But now when I talk to younger law students, if you're a good student, if you're a really good student, if you're doing well, there's just a lot more opportunities than used to exist. So we're going to see a lot more of these folks becoming judges. There's no question about it. But there's another thing that was super interesting about that we've just barely touched on. And I did not realize until I'd read the article. The number of circuit court judges appointed by Republicans and Democrats is tied. And there's one vacancy remaining right now to break the tie. But I had no idea that as of this very instant, until that one vacancy is filled, there's an equal number of Republican nominated and Democratic nominated circuit court judges. Now, as you rightly said, this does not mean there's an equal number of liberals and conservatives, because that's not exactly how it works. Not exactly. But it is that I found that fascinating as well, that we're now at parity on circuit court judges.
And in many ways likely to remain so because of strategic retirements, and then most of the other parts will be randomized when you're talking about 179. That's enough to create enough randomness with the strategic retirements. All right, David, I want to take you back to 1983.
Yes.
And let me just tell you who was on the Supreme Court in 1983. Berger was the Chief Justice. Then the associate justices were Brennan, White, Marshall, Blackmun, Powell, Rehnquist, Stevens, and O'Connor. Originalism had started to exist, but not in any serious way, and not really on the Supreme Court at this point. You had Bork kind of playing around in the shallows with some of his friends, but Meese hasn't given his big speech yet. Scalia isn't on the court to really expound upon it. So we're in what I would call in 1983 a pre-originalism world.
Right.
And we're not that many years removed from the Warren Court, less than a decade. And we're also a decade removed from Roe v. Wade as well. So that just to give you some vibes on what's going on at the Supreme Court in 1983. So a young woman had just graduated from Princeton and had gone to Oxford to get her MPhil. And I wanted to read some portions of her thesis there over at Oxford. Mind?
Please. It is okay. Can I just briefly editorialize?
Yeah.
Okay. First, I want to say we were both kind of hesitant to talk about this because we were thinking about, okay, if someone unearthed my senior paper from undergrad or my 3L paper from law school, what would I think now about it when I'm 55 years old and have lived a lot of life? Like, how fair would that be for somebody to go back and look at that? And so that was one question. But then, so we were a little bit reluctant, but then I read it, Sarah.
I know.
I know.
Great.
It's great.
And look, this young woman was 22 years old when she wrote this. Again, just graduated from undergrad. She had not gone to law school at this point, though she will right after she finishes this thesis. And I'll tell you who she is in a minute. I wonder if you'll be able to figure it out as I read this. But we're not holding her to these opinions now.
No.
It's actually by itself just really thought-provoking and interesting.
100%. I started reading it and I was like, I want to talk about this because this makes a lot of really good points. And you know what it reminds me of? Sometimes you run across 22-year-olds or 20 whatever's in the early mid-20s, and they say something just really interesting.
Yep.
Really interesting and insightful. And so
especially before law school poisons their brains.
Yeah. So I have zero reluctance to talk about this now just because it's really good.
All right. So let me dive in here. We'll start at the beginning. Legal scholars and practitioners alike have often urged the American Supreme Court to pay close attention to traditional standards of judicial method. The late Alexander Bickel once defined such method as the coherent, analytically warranted, principled declaration of general norms. According to Bickel and others, the court should consistently strive to hand down logical, reasoned, intellectually satisfying opinions. The court should further strive to ground these decisions either in the Constitution or in another conventional source of law. Two reasons, one normative, the other practical, have generally been offered for the necessity of the courts making principled decisions. First, some have argued that only the methods of reason and principle justify supreme judicial power in a democracy. Why, after all, should 9 appointed lawyers play so large a role in a democratic nation? only because these 9 lawyers arrive at their decisions in a unique and inherently valuable way, only because these lawyers resolve all issues by reference to law and legal principle. Second, many have asserted that the court's continued position in American government depends upon its adherence to judicial method. According to this view, the court's role in government rests upon the widespread public conviction that the court is acting legitimately. This conviction derives in turn from the court's behaving in a judicial and judicious manner. The Supreme Court, Robert McCloskey has written, must be a court if it is to retain its power. These considerations in and of themselves have significant weight, and yet there is still a third, albeit not commonly mentioned, reason for the court to base its ruling upon legal logic and principle. A decision that has a principled underpinning is more likely than a decision that lacks such a foundation to stand the test of time. Most Supreme Court justices have desired their rulings to achieve some degree of permanence. Not all justices, however, have recognized how best to achieve this result. In order to give lasting effect to a decision, a justice must root it in an accepted source of law, the Constitution, a statute, or a long line of judicial precedents. Further, a justice must buttress each decision with thorough analysis, powerful reasoning, and careful logic. When rulings are not thus supported, they neither command the respect nor compel the acceptance of future courts. Such opinions are vulnerable to judicial manipulation and subversion. They are vulnerable indeed to outright reversal. Thus, the method the court uses to explain a decision matters quite as much as the decision itself. The law that lasts is likely to be the law that is founded upon the Constitution and upon cogent and coherent argument. It is likely to be the law that is founded upon the methods of reason and principle. The history of the Fourth Amendment exclusionary rule well illustrates the dangers and long-term consequences of failing to provide a judicial decision with adequate support. And we're going to return to the history of the Fourth Amendment's exclusionary rule. Yes, we're going to do some Mapp v. Ohio today, David. The exclusionary rule's history thus suggests that justices who wish their decisions to survive should adhere carefully to traditional standards of judicial method. Why, then, did the Supreme Court depart from these standards in its exclusionary rule cases? Why has the court so often appeared to give little thought to the way in which it explains decisions? In all probability, a number of factors contribute to the court's poor record in matters of judicial craftsmanship. This poor record, however, is at least partially attributable to the enormous power that justices possess and the attendant temptations that they face. U.S. Supreme Court justices live in the knowledge that they have the authority either to command or to block great social, political, and economic change. At times, the temptation to wield this power becomes irresistible. The justices at such times will attempt to steer the law in order to achieve certain ends and advance certain values. In following this path, the justices are likely to forget both that they are judges and that their court is a court. Their concentration on ends results leads them to neglect legal means. It leads them to neglect the importance of basing all rulings upon conventional sources of law. This neglect of judicial method is unfortunate, not only for normative reasons, but for pragmatic ones as well. By overlooking the centrality of reason and principle in the judicial process, the justices are defeating their own purpose. The slighting of means and the haste to achieve ends is counterproductive. It increases the probability that the court's rulings will only have temporary effect. The development and subsequent erosion of the Fourth Amendment exclusionary rule amply bear out this point. In their total concentration upon end results, the justices who favored the exclusionary rule unwittingly did everything in their power to assure the rule's eventual demise. So, David, should we drum roll who wrote this?
Yeah, let's drum roll. And then I've got stuff to say about that passage that you just read.
Yes. So this is written by future Justice Elena Kagan in 1983. And I do want to go through the history of the exclusionary rule as she lays it out, because her surprising no one, it's beautifully written. It does a delightful job at 22. I'm not saying you would know this person's going to be a Supreme Court justice, but you're happy she will be.
Classic essay you read as a professor, you say, this person's going places.
That's right.
Yeah.
But David, before we get to, again, the history of the exclusionary rule as she lays it out and some of her opinions on the exclusionary rule since she's been on the court, I mean, I read it, nearly in its entirety, because there's several parts of this that just jump out of 1983 and slap you in the face.
Yeah, I will tell you something, Sarah. This actually reminds me of a different Supreme Court justice's pre-court writings, and that's Ruth Bader Ginsburg. when she was reflecting on Roe, this was in the early 1990s, and putting Roe aside for the moment, one of the things that Justice Ginsburg was talking about is there is a way in which you make decisions that inherently builds credibility. And there's a way in which you can make decisions that inherently creates instability. And that, Justice Ginsburg's point was she liked what she called the interstitial rulings. In other words, step by step by step by step, where you're forecasting your direction, but you're taking that one step at a time instead of the entire leap all at once. And I thought that was very interesting. And I do think that that is something that is a quite valid discussion of the judicial method, because that step by step by step really does reflect kind of the way in which precedent tends to work and get extended gradually over years. And that builds predictability, that builds in stability into the law. And what Justice Kagan is saying here is not the step-by-step aspect here, but what is the method of reasoning? What is the way in which the decision is made? It's not just outcome that builds credibility, it's method that builds credibility. And this is constantly forgotten in our current discourse. Method really matters. Both Ginsburg and Kagan, in different ways and sort of different directions, are making this point that method really matters. And we can go into the exclusionary rule here for a moment, but when she's talking about sort of instability and method, where you say, oh, same outcome, but for this reason, no, this reason, no, wait, this reason, that creates instability because it makes people wonder, wait, what's happening here? Is really the outcome the thing that's mattering, not the method? And if the method doesn't get you to the outcome, what's going on here? So I thought that whole emphasis on the method, both from pre-SCOTUS Justice Ginsburg and pre-SCOTUS Justice Kagan, is really interesting and actually spot on for judicial credibility.
It also struck me that, fast forward to the early aughts, and then Dean Kagan is going to famously say, we're all originalists now, something she has said she regrets saying, as it has been perhaps overly used in...
all textualists now, I think she said.
I think you're right. I think it was all textualists. But this is where, you can see the seeds of this. Like, you have to have a foundation for your opinion. And that foundation, she says repeatedly, should come from the Constitution. So we're all textualists now. I think that's what she's actually referring to, David, is the means matter, not just the ends. And those means have to have some foundation, some real judicial method, and a solid judicial method, whether it's textualism with a capital T or originalism or whatever else, it's going to be textualist. And so let's walk through a little of her history of the exclusionary rule, and I'm going to do this quite briefly, forgive me. But in 1914, in the Weeks case, that's going to be the first time that the Supreme Court, for federal purposes, federal police officers are going to create an exclusionary rule, and they're going to base it in the Fourth Amendment, search and seizure, right? That this is actually part of the Fourth Amendment. But remember, federal law enforcement isn't doing that much at this point. These are basically all gambling rings in all the cases that we're going to be talking about in the federal context. After Weeks, there's going to be another decision, but this time they're going to uphold the exclusionary rule, but now it's based in the Fifth Amendment right against self-incrimination. Then Brandeis is going to come along and give a whole nother reason. The integrity of the judicial system, because if you allow the evidence in, then the judges are participating, if you will, in police illegality. Okay. Then Frankfurter is going to come along in Wolf and say, I've got a fourth reason. Totally different. It's to deter police illegality. Interestingly, the Wolf case is actually also about incorporation and whether to incorporate the exclusionary rule against the states. And remember, incorporation through the 14th Amendment is whether, an individual right from the Bill of Rights applies to the states, because when they ratified the 14th Amendment, they were ratifying these individual rights that were protected from state and federal law enforcement. And so the quote is the right, quote, fundamental to our scheme of ordered liberty or deeply rooted in this nation's history and tradition. So in this Wolf case, basically Frankfurter's going to say no. Then you're going to get the LA Confidential era of the LAPD, as I will call it, where the LAPD does totally insane things, like they bust into some guy's house without a warrant, so he swallows some capsules of drugs. So then they just beat him to a pulp to see if they can get him to vomit the drugs up, and he doesn't. So then they like bound and gag him and take him into like a hospital to get him to throw up the drugs. I mean, crazy stuff. So now the Supreme Court's like, well, this isn't great. So this brings us to the Warren Court. As Justice Kagan describes the Warren Court was on a mission to correct social injustices and inequalities in American life. Chief Justice Warren would often ask during oral argument, but is it fair? And so let me give you the facts of Mapp v. Ohio from 1961. And remember, up to this point, we now have 4 justifications for the exclusionary rule: the Fourth Amendment, the Fifth Amendment, integrity of the judicial system, and to deter police legality. Thus enters Dalry Mapp in 1957, when 3 officers from the Cleveland Police Department arrived at Mapp's home and demanded entry. The officers believed that the prime suspect in a recent bombing was hiding in Mapp's house, and they wished to conduct a search in order to find him. Mapp asked the policemen whether they had a warrant. When the officers conceded that they had no such authorization, Mapp refused to grant them admittance. The policemen informed their superiors of Mapp's refusal and proceeded to wait outside her home. 3 hours later, 4 more policemen arrived on the scene. These officers bore instructions from police headquarters to forcibly enter her home. In accordance with this directive, the policemen kicked down the door to Mapp's house. With the law enforcement officials now in her front hall, Mapp again demanded to see a warrant. One of the officers held up a piece of paper and claimed that it was a warrant. She grabbed the paper and hastily placed it in her bosom. That is Justice Kagan's writing, by the way, and I love that sentence. A struggle ensued, and the 7 policemen succeeded in recovering the supposed warrant. The officials then handcuffed Mapp to her bed for being belligerent and conducted an exhaustive search of her home. They failed to find the bombing suspect or any evidence related to him. They did, however, discover a large quantity of pornographic books and pictures, and they arrested Mapp under an Ohio statute that made the possession of such materials illegal. She, of course, moves to exclude the obscene material on the grounds that the officers had seized it unlawfully. She also, by the way, challenges the Ohio law that makes it illegal for her to possess pornographic books and pictures. Okay, so this is fun, David, because basically all the briefing on the way up is going to be about the First Amendment. And then all of a sudden you get to the Warren Court and they're like, yada, 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 First Amendment. Let's overturn Wolf and incorporate the exclusionary remedy against the states. And so they do, but now Powell, writing for the court, basically just lists all the reasons. So now it's the Fourth Amendment, the Fifth Amendment, judicial integrity, and deterring police illegality. And he sort of goes through them one at a time. They all are supposed to buttress each other. But as Justice Kagan explains, that's not what it does, actually. It doesn't put it on more solid ground. It puts it on less solid ground. Because is this actually a fundamental right, in which case it's coming directly from the Constitution? Or is it judicially created? Or what is this? And so enter the Berger Court, and a Calandra is the name of the case. I might be pronouncing that wrong. And they recreate the remedy. They uphold it, interestingly. But they say it is a, quote, judicial remedy to safeguard Fourth Amendment rights through deterrence, rather than it being an individual constitutional right of the accused. So now it still exists, but if it's not an individual right, it's open to all sorts of balancing tests. They're going to say that it's a cost-benefit analysis. That's how you're going to get stuff like, if it's independently discovered, maybe some good faith type analysis starts coming in. Her argument is that the exclusionary rule is good she doesn't say this exactly, but that it's constitutionally based, and that if they had simply stayed with a Fourth Amendment analysis, the exclusionary rule both would have been applied against the states earlier, it would have a much more solid foundation, and the Burger Court wouldn't be eroding it as quickly as she felt that it was in 1983. By the way, she notes that in between the Warren Court's Mapp decision and the Burger Court's Caldera decision, so between 1960 and 1968, murders rose 52%, rapes increased 84%, assault 86%. By 1969, 75% of Americans thought SCOTUS was too lenient on criminal defendants. Only 2% thought they were too harsh. This is an interesting sort of legal realism section of the paper as well, David, where she's going to say, the Warren Court, by not having this solid judicial method and constitutional basis for their decisions, also failed to bring the public along with them. Nixon comes in and is under a lot of pressure to appoint justices and judges, but justices in this case, who are going to undo the Warren Court's work. And it's easy to do because it wasn't based on anything, and therefore the American public didn't believe in it, so to speak. And so she's going to end with a few quotes. No court should justify its decisions solely by reference to the demands of social justice. That was Kagan herself writing. And then this was a quote that she used a few times during the paper. The law of the future is likely to be the law that earns its perdurance through solidarity and strength of workmanship.
Yeah, well said. Two or three things in response. One, the exclusionary rule discussion is really interesting, especially if you are interested in criminal justice. And how do you get an exclusionary rule when the Fourth Amendment is silent about remedy? So there's a prohibition against unreasonable searches and seizures, but there's nothing about remedy. What are you supposed to do about it? So how does a court approach things when there is how does the court approach the Fourth Amendment when there's no defined remedy? Is it up to the court to craft a remedy? What is the remedy that the court crafts? These are tough questions. So that, to me, is, so the exclusionary rule discussion on those grounds is interesting. We're going to put it in the show notes so you guys can read the exclusionary rule analysis for yourselves if you're interested. But it is fascinating, Sarah. The more you read a lot of the debates and discussions about the law going back 10 years, 20 years, 30 years, in this case, 40 years, the more you realize a lot of the conversations are quite similar to what we have now. We often think that, well, what we're facing is new. These are completely unique arguments. We've dreamed them up in our current generation. No, some of the language has changed. Social justice, for example, political correctness was then a word used more. Then social justice comes back, and then you have wokeness, and then there's all kinds of different words that have been used to describe roughly similar phenomena. But the fact that we use different words deceives us into thinking that we're talking about something totally new. So I think that that's interesting. But then going back to what I said earlier, we're still having these discussions about the judicial method. I mean, this is not something that has ever been settled, nor necessarily will it ever be completely settled. And I just thought it was very interesting to read a thoughtful, putting aside that this is Justice Kagan, a very thoughtful paper from 1983 that just amplifies a lot of the themes that we talk about now 41 years later. That is something that is really interesting to me, how what is old is new again, or what is old and never actually goes away.
So I have a couple thoughts. One, you read this in the shadow of Dobbs right now. Mm-hmm. And I really wonder, to her point, that it wasn't just that Mapp v. Ohio had 4 reasons for the exclusionary rule, but it was also this history of flim-flamming around between reasons. And I really wonder whether if Roe v. Wade had been decided with the reasoning of Planned Parenthood versus Casey, which was on far more solid ground, legally speaking, than Roe v. Wade was, And so Roe v. Wade gets decided, then Planned Parenthood versus Casey upholds it on the same grounds, which is not what happens. Planned Parenthood versus Casey overturns Roe v. Wade basically in its entirety and just creates a new framework.
Yeah.
Not unlike what happens with the exclusionary rule, between it being the Fourth Amendment. Nope, it's the Fifth Amendment. Nope, it's judicially created, and this is why. Nope, it's judicially created, but it's for a different reason. That itself erodes any ability to build the foundation later as well. So it's important to get it right the first time. You can't fix it later on because people already sort of see the Wizard of Oz behind the curtain at that point. Also, I wanted to read this description from her of the Warren Court. The Warren Court believed that it had to assume an active role in the governmental system. The orthodox view of the judicial branch, perhaps best articulated in Hamilton's 78th Federalist paper, conceived of the court as relatively passive bodies. This view assumed that Congress and the president would serve as the initiators in the governmental process, while the Supreme Court would act as a check against transitory inclinations and rapid change. The Warren Court, however, refused to confine itself to this largely negative and restraining role. Time and time again, the court asserted its right to do no less than lead the nation. Essentially, the Warren Court lacked faith in the ability of the president, the Congress, or the state legislatures to guide America in the proper direction. The justices perceived the political process as responsive only to short-term pressures and powerful interests. Elected representatives seemed unable to articulate or enforce the long-range, enduring values that the court saw as vital to the maintenance of a just political order. Only the court could provide justice for minorities and the oppressed. Only the court could ensure the open and egalitarian operation of the political system. Only the court could voice and give effect to the noblest aspirations of the American people. The Warren Court then felt a positive duty to assume an active role in the governmental process. The court became a major initiative supplying agency of American government. During the 1950s and 1960s, many of the most important innovations in public policy stem from judicial rather than from congressional or presidential activity. The court, for example, mandated school desegregation and legislative reapportionment. In these areas and in others as well, the Warren Court goaded America forward while the legislative branch dragged its heels and the executive stood idly by. The court attempted, if necessarily single-handedly, to engineer significant domestic reform. Arguably, the Warren Court became the most innovative and active branch of the American government. I don't even know that that's arguably. I think that's just obviously so. So David, obviously she's describing this with great frustration and negative reaction to it. If I read this from a 22-year-old, this would read as very, very conservative in 1983. Like Justice, at that point, Judge Scalia could have written this in 1983 about the Warren Court. Bork could have written this previous to 1983 about the Warren Court. And what I find interesting, Justice Kagan obviously is not a conservative, but I still see parts of this lingering in her jurisprudence. And in fact, I see it as her main frustration with the conservatives on the court, that they are,
interesting.
In some of these opinions, she believes Warren courting it up. And that the Dobbs decision, which I've said, I think the outcome of the Dobbs decision is correct, but the reasoning of the Dobbs decision leaves much to be desired in my book. I think this is why. I think she puts it better than I ever could, as to why Dobbs was unsatisfying to me in its reasoning and its foundation. And, when she, I think, is arguing in dissent on some of these administrative state cases, of course, I want the presidency to be weakened because I think that's Congress's role. But reading this, I think I understand her point a little more. And again, I'm not holding her to actually that she reads this every night before she goes to bed, like some
just once a week, just
religious text or whatever. But this idea that the worst thing that the Warren Court did was play this active role in American government instead of letting the other two branches work it out. It's a pretty viable argument if you're in 1983 and you've come up through the post-excesses of the Warren Court. And I just find it really fascinating as perhaps this background principle as she criticizes the conservatives. Remember that wonderful line that she has, the get out of text free
yeah, I like that
doctrine, as she described the major questions doctrine. Sort of interesting. I wonder I actually doubt very much that, again, she's even like particularly knows what she wrote in 1983. But it is funny how sometimes you go back and read something you wrote a long, long time ago, David, and you don't recognize it at all, and it doesn't really have your beliefs at all. But sometimes you'll read it and be like, I did not know I already thought that way when I was 22.
Right. Yeah, it's interesting because you know what's so funny, Sarah? We were talking about this beforehand. When you first mentioned this, I actually have my senior paper from college.
What was it about?
And so I went back and I looked it up, and it was talking about how and this is going to be sound really familiar to a lot of people. I was talking about how a rights-based society really can only flourish truly when the government is focused on preserving the rights of the citizens, and the citizens are focused on exercising rights virtuously. Not all citizens, and not all the time, and not perfectly, but it was a meditation on, sort of Edmund Burke and, Thomas Jefferson and John Adams and the letter to the Massachusetts militia and all of that. And I thought, wait, I had this weird thought of, do I have no new ideas?
Right? I mean, are we all fully formed at 22? I'm concerned. That's funny. So through a series of tragic events, I was not allowed to write my senior paper in college. This was the email that I received. I may have mentioned this before. There was about a 3-day I didn't leave my room and I just cried under a blanket moment in my life. I think it's the only one I can think of that was truly devastating. I turned in my proposal. They said no. I wrote back and said, like, look, even if you don't give me the honors designation, I won't regret spending the year writing this paper. Just deny me the honors designation at the end, but allow me to write the paper. And the email I received back was quite short from the head of the history department. And it said, it's not whether you will regret investing the time in us. It's whether we will regret investing the time in you. Which to a 20-year-old was devastating.
Oh my gosh, I can't imagine writing that.
Who writes that to a 20-year-old?
As a professor, I just cannot imagine that.
Anyway, I wanted to write it on Lincoln's use of religious rhetoric during the Civil War, and the title of it was actually from George W. Bush's first inaugural, which I'm sure is why the paper was denied. The race is not to the swift, nor the battle to the strong. Do you not believe an angel rides in the whirlwind and guides this storm? And it was about sort of American exceptionalism and its religious foundation from Lincoln and sort of that refounding concept. And I was very into the concept of American exceptionalism at that point. And here I am, David, still very, very obsessed with American exceptionalism, actually. Something we don't talk about a ton on this podcast. But yeah, I have a very firm belief in it, actually.
David, but I will say I can point to a number of things that speaking of the exclusionary rule, when I was in law school, I was like, I'm not so sure about the exclusionary rule. I don't see it in the text. As I've gotten older, I've been much more along the lines of, okay, there has to be a remedy for this violation. What, this seems to be the most constitutionally sensible remedy for the violation. But yeah, there are, of course, things we can both look at and see that we've changed on. But at the same time, there is moral formation and there's sort of character and ideological formation that takes place. And no question, elements of it stick.
So, David, can I tell you a little bit how this story ends? Because Justice Kagan, now a Supreme Court justice, has had exclusionary rule cases on the Supreme Court. And I thought this one from 2016 was interesting. Utah v. Strife. It's 5-3 because Justice Scalia has passed away. And she is in dissent. So in the majority, it's Roberts, Kennedy, Breyer, Alito, and Thomas. And in dissent is Sotomayor, Ginsburg, and Kagan. So let me read you the paragraph from her dissent. If a police officer stops a person on the street without reasonable suspicion, that seizure violates the Fourth Amendment. And if the officer pats down the unlawfully detained individual and finds drugs in his pocket, the state may not use the contraband as evidence in a criminal prosecution. That much is beyond dispute. The question here is whether the prohibition on admitting evidence dissolves if the officers discover, after the making of the stop, but before the finding of the drugs, that the person has an outstanding warrant. And of course, the majority holds that that intervening moment of finding the outstanding warrant now cures the search and that you can still use the evidence at trial. Justice Kagan saying no, because there's millions of outstanding warrants in the country. And it's basically like the lottery for police officers that as long as they can find an outstanding warrant, suddenly they can search someone who they otherwise had no right to pull over. So Justice Kagan still very much in favor of the exclusionary rule. And interestingly, at the end of her paper, she predicts the fall of the exclusionary rule, or that the exceptions would, eat the rule itself, that there would be basically a good faith exception as long as the officers weren't sort of LA confidentialing it as they were in the wake of Weeks and Wolf, that it would be gone. And she actually proved incorrect on that. So the principles may have remained to some extent, but we're pretty bad at predicting, as it turns out.
It's true. That's true.
David, we're going to finish up with a little dissental coming out of the Ninth Circuit. This is from Judge Bumate. I went to law school with Bumate. I consider him a good friend. Disclosure, disclosure, disclosure. But this is fun. So in Oregon, if you want to have a recall election for a government official, you can circulate a petition. The petition has to have the signatures of 15% of the electorate, and you have 90 days to collect and submit these signatures, which is not a lot of time, David. So
Right.
If you're trying to recall a statewide official and you need 15% of the voters in Oregon in 90 days, that's going to be tough. Now, on the other hand, if you want to recall a city council member, maybe less tough, although again, your pool's smaller. So 15% out of a small pool, maybe still really tough. Well, this group actually weirdly meets the 15% threshold and does it in the 90 days, but they file a lawsuit arguing that this is unconstitutional. And the panel at the Ninth Circuit agrees. They say that these sorts of restrictions have to meet strict scrutiny, as in they have to be narrowly tailored for a compelling government interest, and that basically 90 days is not narrowly tailored, it's not a compelling enough government interest, yada yada. So Judge Bumate circulates this for en banc review to overturn the circuit precedent that this was based on, that strict scrutiny part of the circuit precedent. And he does not get enough votes. So here's his dissental from en banc. And remember, dissentals are like little love letters to the Supreme Court. We can't file our own cert petitions, but it's like when someone does file the cert petition, it's like a recommendation letter from your professor. This is the best student I've had all year. Love Judges Bumate, Bennett, Nelson, and Van Dyke. So I just wanted to read a couple paragraphs from it. The right to speak out is not a right to prevail. While the First Amendment guarantees freedom of speech, nothing in that constitutional provision means that a person's position on an issue must become law or even be voted on. A dissenting opinion, like this one, provides a fitting example of this principle. I called this case en banc because I thought our court needed to reconsider our decision in Engel. In that case, the Ninth Circuit held that the First Amendment requires that we apply strict scrutiny to any regulation that significantly inhibits the placement of voter initiatives on the ballot. Engel needs to be revisited because it departs from the text and historical understanding of the First Amendment. But a majority of my colleagues disagree. Because there weren't enough yes votes to rehear this case en banc, Engel remains the binding law of the circuit. While our failure to jettison this precedent was wrong, no one would seriously contend that my inability to prevail on an en banc vote means that I was unable to effectively address the legal issues brought before our court. That my views are relegated to a dissental doesn't mean that my judicial role was inhibited or that our en banc rules need fixing. The same goes for free speech. Having strong views on a political issue doesn't equate to a right to have the issue voted on by the people. But this is the slippery slope that Engel creates. It extrapolates a right to put an issue on the ballot from the right to advocate for an issue. That's simply incorrect. In our Republican system, states are under no obligation to allow their citizens to legislate directly, yet through history, states have done so. States have long experimented with direct democracy. He goes on to talk about this. Into this realm of direct democracy, the Ninth Circuit has inserted itself and the First Amendment's free speech right. Engel subjects any ballot access rule to exacting judicial scrutiny if the regulations make it too difficult for the direct democracy petition to succeed. This applies even if the rules are neutral, procedural regulations. Nothing in the text, history, and tradition of the First Amendment supports the expansion of judicial power over state ballot initiatives and other direct democracy petitions. David, how do you feel?
Okay. This is one of those things where when I first looked at it, I'm a First Amendment attorney for most of my career, vast majority of my career, have a zealous defender of the First Amendment. And I'm literally stumped at the idea that there's going to be a strict scrutiny applied to any regulation that significantly inhibits the placement of voter initiatives on the ballot when there's no right to put voter initiatives on the ballot in the first place.
Indeed.
In other words, you don't have a right to live in a state that has voter initiatives on the ballot. Now, if the state gives you that under the state constitution, great, fine. But this is really fascinating that this appears to be, one of these doctrines that the court has said, well, we like voter initiatives. Direct democracy, good, yay. Okay, well, that's a very defensible position on a policy basis. I don't necessarily agree with it, but it's a defensible position on the policy basis. But where is this coming from? This idea that, what's the textual basis? What is the basis here for this idea that a restriction on a ballot initiative when there's no right to ballot initiative? Now, to be clear, once you create something, when you create a ballot initiative process, that process, because it's a state-created process, is going to have some constitutional restrictions around how it's used. So, for example, even though there's no right to a ballot initiative process, you couldn't say, well, only white voters can sign it, and then defend that discriminatory rule on the basis of, well, you don't have a right to begin with. Now, once you create the process, it is true that there are some constitutional obligations that are going to attach. But this idea that a restriction on an activity that there is no right to in the first place is going to be subject to strict scrutiny, pretty remarkable. And I thought that was a very effective way of articulating it.
I will continue with a bit of the dissental, which I enjoyed. Ultimately, it's federalism that suffers. Following Engel and its progeny, courts within the Ninth Circuit have taken it upon themselves to rewrite the neutral, non-discriminatory state procedures that structure ballot initiatives and the like to give proponents a better shot. Absent content or viewpoint-based restriction of political speech, states should be free to experiment with ballot initiatives, recall initiatives, and referenda as they see fit. These decisions involve fundamental questions of state policy and the fine-tuning of the democratic process, as we of the least democratic branch of the federal government must tread lightly here. Indeed, if the First Amendment protected against rules that make some political outcomes less likely, that would be grounds for federal courts to intrude on all sorts of state political activity, like state supermajority rules and veto rules, and may discourage these direct democracy petitions. Since Engel has no support in history and tradition of the Supreme Court and comes at a great price to federalism, we should have reconsidered it en banc. Here, no hot-button issue proposal looms over the case. No election awaits right around the corner. No emergency stay hangs over the parties. Safe from the pressures of a political battle, we should have reconsidered Engel when we could give it our best attention. David, I think he is 100% right. The reasoning behind this is bizarre, that one political outcome, meaning direct democracy good, is up to the courts to put their thumb on the scale, just has no basis in anything. And in fact, will discourage direct democracy processes in other states if then it becomes a court-mandated direct democracy process where you have to have a lot more direct democracy once you crack the door open. That all being said, I don't think the court's taking this one.
No, I don't think so. Like a little quirky Ninth Circuit rule about direct I don't.
Sorry,
I don't think so either. I know.
Judge Bumate.
I know. You're right, Judge. You're
Judge. Totally right. But I don't think this is going up to the big house. Sorry.
Yeah.
All right. Well, next time on Advisory Opinions, we have a Fifth Circuit decision on what exactly Election Day is. Speaking of constitutional rules applying to direct democracy, as well as a DC Circuit decision affecting January 6th prosecutions and whatever else may pop up in the meantime next on Advisory Opinions.